The municipal court shall have the powers and jurisdictions in the city as are now provided by law for the justice court. If I had a mic, I'd drop it.
All rise. Judicial District Court, Department 12 is now in session. Honorable Michelle Leavitt presiding. Come to order. Be seated, please.
We have both sides here on Patterson.
Yes.
C368270. You can make your appearances.
Stephen Stubbs, bar number 10449 for Mr. Patterson.
Carlene Helbert, bar number 9830, on behalf of the city of Las Vegas, Your Honor.
Okay. Mr. Stubbs, do you want to be heard?
I would love to be one. Thank you.
Hang on, Chancellor. Sorry, sir.
Your Honor, thank you for this opportunity. To start off, I believe because of page 18 of the answering brief, the city's brief, I need to clarify something because otherwise this is going to get real confusing very, very quickly. On page 18, the city connects NRS 41.0393 with vindictive prosecution. And that's just not correct. So we need to clear that up so that we can move forward. There are four words you might hear today. Vindictive, frivolous, bad faith, and vexatious. There is vindictive prosecution, which has a completely different standard of proof for everything else. The standard of proof for vindictive prosecution is mere appearance, even lower than reasonable suspicion or probable cause. Mere appearance. And that vindictive prosecution comes to us by United States Supreme Court case law. Then, with 41.0393, there's frivolous prosecution, bad faith prosecution, and vexatious prosecution. Now that standard of proof, it's tiered. That standard of proof is clear and convincing evidence because it's to possibly punish the prosecution with prosecutorial misconduct. So even the standard of proof separates the two and they have completely different purposes. Now, with regard to frivolousness, which you are not, but just so you know what they are, because you might hear some things because of the statute. Frivolous is when the prosecution takes a position that is foreclosed by binding authority. Bad faith is frivolous plus. It's frivolous plus evidence that the prosecution knew better. Not should have known better, but knew better. Then vexatious is frivolous plus bad faith plus evidence of unrighteous motives in addition to the frivolousness and the bad faith. And that is the standard for attorney's fees that the lower court must determine. That is not before you today. On that issue, the only thing before you is whether or not the municipal court has jurisdiction. So this court should not decide on frivolous, bad faith, or vexatiousness. It's not ripe, and that's for the other court. Now, secondly, the vindictive prosecution. This court can decide the vindictive prosecution because Judge Kearns substantively found that the city vindictively prosecuted Mr. Patterson. But he erroneously allowed the city to cure their vindictiveness by amending the complaint. Now, the standard again for vindictive prosecution.
Is it your position that they can't amend their complaint? I mean, because you're obviously appealing from that decision.
Yes.
So the next thing I want you to do is tell me how this court has jurisdiction what rule or statute allows you to appeal the municipal judge's decision to allow the city to amend their complaint?
Are you talking about mootness, Your Honor?
I'm talking about jurisdiction.
Well,
how does this court even have jurisdiction to rule on whether Judge Kearns was appropriate in allowing them to amend their complaint? Because you're clearly appealing that decision.
Yes, Your
That's
Honor.
your first issue.
The Nevada Constitution gives you total jurisdiction to hear anything within the jurisdiction of the municipal court. You have that specifically. You are the final appellate decision for the lower courts, including the Justice Court and the Municipal Court. So that jurisdiction to appeal that particular issue comes from the state constitution. Now, vindictive prosecution, again, it's the mere appearance standard, which we all know it's very different than clear and convincing, right? That's a due process violation created by the United States Supreme Court in 1974. And it's a species of prosecutorial misconduct, which occurs when the government brings criminal charges in response to a defendant's exercising a protected statutory or constitutional right. What happens is the defense needs to establish the mere appearance of it. Then the burden of proof shifts to the prosecution for them to rebut that standard and prove that there is no.
What's the remedy?
The remedy is two. One is specifically a vindictive prosecution ruling, and that is meant to offset the chilling of the exercising of the constitutional or statutory right. And then number two, it is the dismissal of the charge.
Okay, because the charges were dismissed. I mean, because it's interesting procedurally, because the city dismissed both counts, correct?
No, the city didn't. There was only one count. That was part of the problem.
Right.
There was one count that was two things. It should have been two counts. Okay. So according to vindictive prosecution, you dismiss the whole count even though it was attached to something else, right? That's what should have happened. But Judge Kearns allowed them to cure by amending the complaint and taking out half of it. And the rest moved forward.
They took out the language that wasn't appropriate.
Yes.
Right.
And then that was the vindictive prosecution, right? And he found substantively that it was vindictive prosecution, right?
I'm not sure I agree with that. I mean, I agree with you that he said what he said, but I'm not sure that he made a ruling.
Oh, I believe so in right. We can certainly get to that, Your Honor, right? And so on the second count, there was a probable cause hearing. Mm-hmm. And at the probable cause hearing, Judge Kearns found that there was not probable cause and that Mr. Patterson had a constitutional right to do what he did at that point. So there were two parts that he found there. That was dismissed, and then just the traffic count remained. That was eventually dismissed by the city.
Right, because the person didn't show up or it was set for trial. I mean, so basically you're appealing, charges that have been dismissed.
Yes, and the reason that we're doing this is to negate the chilling. This chilling, and the Supreme Court has talked about this, the United States Supreme Court. This chilling is important. It's the entire reason why we have vindictive prosecution. And the United States Supreme Court has even said, I'm going to go forward just a little bit. In Black v. Perry, which was the first of a long line of vindictive prosecution cases, since 1974, new ways to vindictively prosecute it have come out. There's one that's the most popular one that dominates most of the case law. But with Black v. Perry, it said vindictive prosecution findings are necessary. Again, the finding of vindictive prosecution is necessary to quell the concerns that the fear of prosecutorial vindictiveness will have a chilling effect on citizens exercising their constitutional rights. So the mere finding, the court needs to say this isn't right. The court needs to say this is vindictive prosecution. And that's the only thing.
So you contend Judge Kearns did, so what's the issue?
He
If
didn't
Judge
say
Kearns,
it.
That's what that was.
He didn't
my
say it. In
point.
fact, he said it could cure, which the Ninth Circuit has specifically said you cannot do. You cannot cure the chilling by amending the complaint, and that's in a Ninth Circuit case. In U.S. v. Motley, 655 F2D 186, the Ninth Circuit specifically established in 1981 that the government's voluntary dismissal did not cure the appearance of vindictiveness, and therefore the chilling remained. They went on. Once the government has created the appearance of vindictiveness, it cannot, by its own self-restraint, cure the chilling effect of its own original action. Your Honor, we are asking you to really cure the chilling effect that happens when a prosecutor decides to prosecute somebody specifically for exercising their important constitutional rights. Because when that happens, the prosecution puts a stamp of approval on the police's wrongful misconduct, and we can't sue the prosecution. They're immune. They have prosecutorial immunity, especially in the state of Nevada. We have some of the strongest prosecutorial immunity statutes that are out there. There's no other way for anybody, citizens, not just Mr. Patterson, to feel comfortable now, because if the police do something wrong, which they continue to do wrong things with this, it's continual. That's in my reply as well. When the police do something wrong, the prosecution is supposed to look at it and say, the Constitution says you can't do this, officer. I'm sorry. We're not going to file charges. But here, they filed charges. Then, I brought Mr. Patterson's video to them and in open court handed it to them, and I simply said, Judge Kearns, let's set it for a status check. I think they're going to watch the video and they're just going to dismiss it. And Deputy Ruggiero said, oh no, we're not going to dismiss this defendant. That's not going to happen. Why? Because Mr. Patterson is a known activist. He's a police accountability activist that is not popular with prosecutors. He is not popular with police. He's the leader of Nevada Cop Block in Nevada.
Nevada what?
Cop Block. It's an online journalism to where if a police officer does something wrong, they make it public. That's what happens. And he's very unpopular with all of them, so much to the fact that he has twice got rulings both at the Ninth Circuit and at the Nevada District Court saying that the police target him specifically. And one was my case, and he got a $120,000 judgment for it because the police target him. The Ninth Circuit said the police target you. They made an exception to a standing law specifically because it was clear that the police were targeting him and it would violate his First Amendment rights. That's twice that's happened. So without even looking at the video, the prosecution says, I'm not going to dismiss this case, not against Mr. Patterson. That's on the record. It's on the record. And then when I tell Mr. Kearns, Judge Kearns, I say, okay, Judge Kearns, we'll do a motion for attorney's fees. Judge Kearns, without hearing anything about the case, says, I'm going to deny your motion. That's on the record. This was a sham from the get-go. And so, when vindictive prosecution is established, and Judge Kearns specifically said, yes, you had a right, and they prosecuted you for that right. But they cure that prosecution by amending the complaint, doing what the Ninth Circuit says he specifically cannot do because it leaves the chilling. Not just for Mr. Patterson. Mr. Patterson is strong. He's still going to stand up for his rights. What about everybody else? Because do you know what? The prosecutor is not going to stand up for your constitutional rights. That's the message that's been sent. That's the message that currently stands. I sent Deputy Ruggiero an email. Here's all the case law, United States Supreme Court, all the case law, right? Please just dismiss that charge. Right? At that point, he could have done exactly what he did later, and I would have accepted that. But he said no. Even knowing United States Supreme Court, Nevada Supreme Court, I even sent him some of the training manuals for Metro that said that this was wrong. He said no. And then I went on and I said, I prepared the motion. I sent him an email. You have a copy of the email in the exhibits. A copy of the email. It said, please don't make me file this. All caps in the subject. Please don't make me file this. And then he called me the morning I was going to file it. And he told, after we discussed things, he said, file your motion. So knowing that it was wrong, knowing it was violating Mr. Patterson's right, he still said, file your motion. Then, evidently he had a change of heart then. Because all he had to do was say, I'm gonna dismiss the charge then, and I wouldn't have filed the motion. Then he doesn't even substantively oppose the vindictive prosecution. We'll get to that in just a minute. Then he files a motion to amend the complaint. And he doesn't substantively dismiss it. Now, I'm sorry, substantively combat the vindictive prosecution. He doesn't assert any of the defenses. He did nothing. He essentially acquiesced to the vindictive prosecution. Then, when Judge Kearns in the September hearing asked him, why didn't you bring up any of these issues? He specifically said, because you already said you were going to rule in my favor. Because on the first day, before anybody saw anything, the prosecutor said, I didn't waste my time with this because you already said that I was going to win this thing. That's on the record. That's in my brief. Talk about chilling. I mean, it's frigid. It's frozen. That this would happen in a courtroom in the United States of America, where the prosecution, without even looking at the evidence, makes a decision of guilt or innocence and completely disregards constitutional rights. Then when I send him the documents, he completely disregards. The judge on day one says, I'm going to deny your motion. The prosecutor doesn't even contest it. But the judge says, okay, you're right, Mr. Patterson, you're right. You had a right to do this. However, they cured, and he uses the word cure. They cured by amending the complaint. When we have United States Supreme Court saying that the important part of vindictive prosecution is the vindictive prosecution finding. Judge Kearns needed to say, not say he cured it, say, there's vindictive prosecution here. Now, what does that really do, right? The standard for vindictive prosecution is so low that it doesn't even meet a bar complaint. Prosecutorial misconduct is clear and convincing evidence, where this is mere appearance. You can't even get a bar complaint out of a vindictive prosecution. Now, you can get a bar complaint after you have a vindictive prosecution, something, and then you move forward, because at that point, it's on the record, you know you're not supposed to do it. So, just like a cop writing a warning ticket, that's what vindictive prosecution is. Just like a cop writing a warning ticket, stop speeding in a school zone, warning ticket. Next time that pops up, then they're going to nail you. That's what vindictive prosecution does. That's why the finding is important. And that's why you cannot cure by amending the complaint, because the chilling remains. They dismiss the case, great. But everybody out there knows that the city of Las Vegas is not going to have your back. The city of Las Vegas is not going to care about your constitutional rights, even when your attorney gives them United States Supreme Court precedents, Nevada Supreme Court precedents, that's on all fours. They didn't care. That's what Deputy Ruggiero did. That's why the finding is so important. And you actually, Your Honor, according to the Nevada Constitution, you have powers that Judge Kearns doesn't even have. As the appellate court, you have powers to issue an injunction. You specifically have that. You can issue an injunction that not only was this vindictive prosecution, not only can you not cure because the Ninth Circuit says so, binding authority, but, city, I'm going to issue an injunction that if a person gives their legal name, then you cannot file a charge against them for obstruction for not identifying yourself. Why? Because that's what the Nevada Supreme Court and the United States Supreme Court in Heibel found. Binding precedent. They can have an injunction. That really takes away the chilling. We now have something. We have something that not only for the city, but that's a warning to everybody. Look, the Supreme Court said this, right? Judge Boulware at the Nevada District Court has said it in another case that I have, in writing, that the ruling came 2 months before Mr. Patterson was arrested for it. Boulware says stop, right? But then they arrest him for it. Then the city brings it up. Do you see the problem here, Your Honor? Do you see why there's such a chilling and why you need to invoke your powers that the Constitution of the state of Nevada gave you to take this chilling and warm it the heck up? We need this chilling gone so that Nevada citizens have the strength and know that there's something that has their back so that they can do everything the United States Supreme Court says, everything the Nevada Supreme Court says, and not be prosecuted for it. Because they're doing exactly what the law says they're supposed to do. And Metro doesn't like that law. Too bad. There's a Constitution. The Constitution doesn't always make their job easy. And I'm sorry, but that's what the courts have said. That's why this is important here. Now, on the second issue of jurisdiction for NRS 41.039. Yes, it says it applies to district court and justice courts. Does not say municipal court. Yes, they define court as district court and justice courts. However, you have to look at the other statutes as well. NRS 266.550, parens 1. The municipal court shall have the powers and jurisdictions in the city as are now provided by law for the justice court. If I had a mic, I'd drop it. That's what it says. If it's good for the justice court, it's good for the municipal court. Since 1907, that's how the legislature has been legislating the municipal court. And actually, the original 266.550, which since then has split to where there's the 266.550 currently, and then there's also NRS 5.073, because they added some things to it, right? So, with that, since 1907, the legislature said, we don't have to add municipal court to everything because it's automatically there. Now, the city has said, oh, you're going to open up the floodgates. They make this argument in their answer that, oh, now we're going to have civil cases. Now we're going to have this, that. No, the Nevada Constitution specifically says that the municipal court only has the right to do things for municipal purposes. So all that goes out the window. There's no way those floodgates are getting opened. There's no way any of that can happen. The Nevada Constitution doesn't allow that to happen. But if there is something that happens in the justice court and also happens in the municipal court, criminal cases, the jurisdiction is the same. That's what 266 says. Now, additionally, NRS 5.073 ties practices and procedures of the justice court to the municipal courts. So if it's a practice or it's a procedure, In the justice court, or I'm sorry, in the municipal court, you bring in the justice court's jurisdiction. You bring in the justice court's practices and procedures, right? It's an automatic thing, and this is the way they've been doing it since 1907 to make sure everything's consistent throughout the state. To make sure we don't have a municipal court in Boulder City that's doing a different thing than the municipal court in Pahrump, right? They want it
The
consistent.
legislature knows we have municipal courts.
Mhm.
I mean, one of the sponsors was Aaron Ford.
Mhm.
He's now the Attorney General. If they wanted it applicable to the municipal courts, they could have specifically said municipal courts, and they didn't. I
That-
mean, and it's a very specific statute, and it's a new, it's a new thing.
If it's a case to where it could go, if there are two reasonable interpretations, right? If there is two, just two. If I have a reasonable interpretation and the city has a reasonable interpretation, the tiebreaker is always the legislative intent. The legislative intent never mentions excluding the municipal court. In fact, they do the opposite by saying all prosecutors. They are prosecutors. So I believe the legislature has done what they've done since 1907 and relied on NRS 266.550 and relied on NRS
Then they
5.073.
wouldn't have had to define court. But they specifically did define court.
They defined it as a justice court, right?
That's the issue that I'm having, is that they specifically defined what court means. If they didn't, then I think your argument would be better.
Let's go down that road. They specifically find it to say that this is the justice court. Okay? Now, the only other question then, if we forget 266.550, because that says the jurisdictions are the same. Okay? Even if we forget that, which I think is a mic drop moment, the question is this a practice or procedure of the justice court? If it is a practice or procedure of the justice court, NRS 5.73 automatically brings it in, the same way that 266.550 should have. And in order to prove that this is both, it only has to have one. Both a practice and procedure of the justice court, you only need to look at the first 7 words of the statute. NRS 41.0393. It says, a court may, comma, in a criminal action. A court may, this is what a court may do. That's a practice. By definition, that's a practice. Therefore, NRS 41.0393 is a practice of the justice court, and pursuant to NRS 5.073 automatically attaches to the municipal court. But then it says, in a criminal action. This is not a new proceeding. This is not like other statutes that say, for the Second Amendment, you can, when the case is done, you can then file a new civil proceeding and get your attorney fees. Because there's that statute too. They didn't do it that way. They placed this one specifically in the criminal action. That's in the statute. So it's part of the proceeding. It's a part of the actual criminal proceeding. So if it's a part of the proceeding and there's already jurisdiction for the proceeding, then we're there as well. NRS 5.073 brings it in. We've got 2 statutes that bring it in. We have nothing that excludes it. And if you're going back and forth at all, if you say, do you know what, yours makes sense, Mr. Stubbs. Oh, yours makes sense, city. If you say that, the tiebreaker, if there are 2 reasonable interpretations, the tiebreaker is the legislative intent, we win that one hands down. Because over and over again, it says all prosecutors. And they never discuss, they never mention excluding municipal courts or anything like that. They rely on what's already there. They rely on NRS 266.550 and NRS 5.073. And I'd like to say, there are many other statutes that say in district court and justice court and move on. And those all are brought in to the municipal court through NRS 5.073. The case that I cited in my opening brief is an example of that, to where the municipal court wasn't even a party to that case. The statute, now the facts are not the same. I'm not saying the facts are the same. What I am pointing out is the statute that was being looked at specifically said in district and justice courts, did not say municipal courts. And they brought it up on appeal. It went to the Nevada Supreme Court. The Nevada Supreme Court made their decision, and sua sponte, because they weren't even a party, says, by the way, this also attaches to the municipal court pursuant to NRS 5.073. They weren't even a party, and then they specifically said that, establishing the precedent that, hey, if it says district court and justice court, and it's a practice or proceeding, it comes in. It's automatically attached to the municipal court. I'm through, Your Honor. Is there?
No, thank you. Thank you very much for your presentation. And I'm assuming the city wants to be heard?
Just briefly, Your Honor, and I appreciate Mr. Stubbs' passion, but I'm going to just kind of keep to what I think the legal issues are before this court today, and I think you've touched upon. The first issue, I think, is that Mr. Patterson simply has not met his burden of proof to show that you have appellate jurisdiction over the issue of whether the municipal court properly allowed the city to amend its complaint. Again, appellate rights are governed by statute. There is no statute that says you have the authority to decide an issue in a case that was ultimately dismissed. Assuming that's not the case, it is untimely. The final judgment in this criminal case was when the case was dismissed. Patterson's notice of appeal is beyond that 10-day time limit. Looking to the federal government, the federal courts for persuasive authority on how they deal with the Hyde Amendment, they treat the applications for attorney's fees and costs as a quasi-civil proceeding that is independently appealable. And that's what would happen in this case, is you could appeal the criminal case if they were found guilty, and then there would be a separate appeal for the attorney's fees and costs. So it does show that it's untimely, and it is similar to like a motion to return property once somebody is found not guilty. If you find that somehow doesn't meet his lack of showing jurisdiction to establish appellate rights, then it is moot. Again, as we pointed out in our brief, the requested relief, this was a motion to dismiss for vindictive prosecution, was in fact granted. All the cases relied upon by Mr. Stubbs was for the court to reconsider and to dismiss the case. The case was dismissed. All of the arguments that Mr. Stubbs has made in court here today and in his brief can be made to the municipal court, saying, hey, I know you said that, it wasn't vindictive prosecution, but you shouldn't allow them to cure it. I still think it serves its purpose for potential attorney's fees and costs. That can be brought down below, and then it can be appealed if that's incorrectly. But it's also moot because the municipal court just doesn't have jurisdiction. And so whether or not they should have granted that is also moot because they can't decide an application for attorney's fees and costs. And that's the second issue, Your Honor. Essentially, again, pretty simply, the plain language of NRS 4.41.039 clearly and unambiguously limits applications for attorney's fees and costs to justice court and district court. The perennial canon of statutory interpretation is that when the language of the statute is clear, you apply that plain meaning and you do not look beyond it. And that is exactly what Mr. Stubbs is arguing that you do. He acknowledged, yes, it says all that stuff, but I want you to look at Chapter 266 of the NRS. I want you to look at Chapter 5 of the NRS. That's not the statute at issue. The statute at issue is NRS 41.0393, and it clearly states courts mean justice court and district court. As I pointed out in my brief, they had the opportunity to not include that definition, but they decided to. They had the opportunity to include municipal court within that definition. They did not. And so we must take the plain meaning of that statute and apply it just like the municipal court did. It is crystal clear. We do not get into legislative intent. Mr. Stubbs again talks about other statutes that say justice court and district court, and they incorporate municipal courts. Those statutes don't define courts. NRS 41.0393 defines court as justice courts and district courts, and it is therefore limited to those courts. The plain meaning is crystal clear. The municipal court does not have jurisdiction. Thank you.
So that first little soliloquy I had at the very beginning, to where I said it's important that we divide up and don't mesh things together. The city just did exactly that, just like they did in their answering brief. They mentioned vindictive prosecution together with attorney fees under 41.093. And that's what I was trying to clear up. It's not the same. Vindictive prosecution is completely separate. That goes into frivolousness, bad faith, and vexatiousness, right? And so you can't bring in the vindictive prosecution into the NRS 41.093. That's completely separate. Number two, she says that we should look to the Hyde Amendment. And although I will concede that the statute was crafted after the Hyde Amendment, the procedures of the federal court are very different than the procedures of state courts, municipal courts, justice court, district courts. Very, very different. There is nothing in this statute that says that you follow any of their procedures. We have to follow our procedures. We can't just automatically start going and the federal rules of evidence and the federal rules of appellate procedure. We can't do that, right? And so anything to where they're talking about the Hyde Amendment together with 41.0393 with practice and procedures, we can't do that. We have to look to our laws. Our laws I've already showed you is 266.550, NRS 5.073. As such, they say it's a quasi-civil action. Well, on the federal level, yes. The statute specifically says here, in a criminal case. It is specifically, by the plain meaning of the statute, not a quasi-civil action in the criminal case. It's part of the criminal case. They specifically made it that way. And so to say this is quasi-civil, there's just nothing to back that up. Dealing with jurisdiction, NRS 177.015, which actually happens to be the discussion in Sandstrom v. Second Judicial District Court, 121 Nevada 657. It's a 2005 case. That establishes that you can appeal anything that happens inside the lower court to the district court upon final judgment. So whenever there's a final judgment, you can appeal it. Now, the city seems to be thinking we should have filed an interlocutory appeal, right? I don't believe, well, first of all, the courts have looked down on interlocutory appeals by defendants in criminal cases. They want everything to be hashed out and then one clean appeal to come up. That's the case law. That's what happens. I considered an interlocutory appeal and then realized that's a waste of time. That's not going to be granted. I have to wait till the final judgment. And it specifically says...
Appealing a judgment of dismissal, right? I mean, because it was dismissed.
No, it was not dismissed.
The complaint was dismissed.
No, it was not.
There's a complaint still pending in municipal court?
Okay. At the time period, we're talking about November 1st, 2021. Okay? November 1st, 2021.
At the final judgment, the complaint was dismissed.
Yes.
Okay.
Yes. Yeah. But that's not the date of the final judgment, right? Because so what they're saying is that when there was not a dismissal, there was in November 1st, 2021, when they were allowed to cure the vindictive prosecution, there was not a dismissal of any complaint or any it's good. There was no dismissal. They took an issue that had two parts to it, and they took away one. But it wasn't dismissed. It was still alive, and it was still alive and well. Now, the definition for final judgment isn't even necessarily the dismissal. A final judgment is an order that disposes of all issues and leaves nothing for future considerations. Until all issues are disposed of and leave nothing for future considerations, NRS 177.015 doesn't even kick in. I have to dispose of all the issues unless the one exception to that is interlocutory appeal, which I didn't believe was proper. And so the final issue to be decided here was the attorney's fees application, which specifically says in NRS 41.0393, specifically says that that is in the criminal case. That was an issue. And as soon as it was denied for lack of jurisdiction, I filed the appeal timely. So we have not only the Nevada Supreme Court, or I'm sorry, the Nevada Constitution that I already talked about, we specifically has NRS 177.015 along with Sandstrom, the Nevada Supreme Court Sandstrom, that says that as soon as all issues are disposed of, that's when I can appeal Mr. Patterson's case to the district court and before you, Your Honor. So the entire untimeliness, it attaches to the last issue, right? And that's important. It's important because then we don't have all these interlocutory appeals. We don't have anything messy. It's not going up and down, up and down. You resolve all issues and then you appeal all issues. That's why they do it that way, which is important. Now, as far as mootness.
But at the end of the day, you're still appealing a judgment of dismissal and the denial of attorney's fees.
Actually, I am not appealing a judgment of dismissal. Well, there's two things. I've got to separate the two. There's the vindictive prosecution and there's NRS .0393. With the vindictive prosecution, there was never a judgment of dismissal on the issues that were vindictive prosecution. There was an allowance to amend the complaint, and that charge remained. That charge was not dismissed until later on, when there was a probable cause hearing, and Judge Kearns found specifically that one, Mr. Patterson had a constitutional right to do everything that he was doing, right? To delay the moving to the front of the police car while he's trying to work things out with the officer. He delayed it for 50 seconds, right? He had a right to do all of that, right? And then number two, the city could not provide probable cause of the obstruction. So it was dismissed at that time on probable cause grounds. The charge remained active and was just simply amended, right? Now from there, we then had to do the issue of the traffic ticket. Okay, once that was done, I immediately filed the application. Few days, I filed the application. That was a remaining issue. Now, again, NRS 177 specifically says final judgment is when no issues remain. And this was not appropriate for an interlocutory appeal. So everything was timely. Now, dealing with mootness. For one thing, I would say that it's not moot because the vindictive prosecution has everything to do with NRS 41.0393. While because of the difference of standard of proof and even the difference of elements, right, a vindictive prosecution finding can be used to try to prove the frivolousness, the bad faith, the vexatiousness. It's not an automatic. You don't automatically get one, right? But that can be used to. So it's still tied to NRS 41.0393. So it's not moot for that very important reason. Additionally, when something is likely to come about again, I'm not thinking of the exact words.
I hope it's not something that will be repeated.
Oh, Your Honor.
That it's repetitive.
Your Honor, I think it absolutely is, and Metro has shown that it will be. And frankly, our system and the way we do it, with the hundreds of cases that they deal with, you cannot tell me that they look at each individual case and read each individual case to determine whether or not to file. They rely on what Metro tells them. They rely on that, and they file cases. Vindictive prosecution by the United States Supreme Court happens at the filing of the complaint. I didn't even have to give them time or say, please don't make me file this. I had the right to file vindictive prosecution on day one. I gave them that. I gave them that respect. I gave them that opportunity, right? So that we didn't have to go through all this. And frankly, if they just make a mistake, I'm going to give them some grace. And that's fine. Vindictive prosecution happens at the filing. That's it. I could have done it. They vindictively prosecuted him from day one. But I waited and I tried to convince them, showing them everything. I did everything I could to make sure this didn't happen. All they had to do was the right thing at the very beginning. That's all they had to do. But Metro, I had another case like this that took 7 years. And it went to Judge Boulware. And Judge Boulware said,
7 years in municipal court?
no, a federal case.
Oh, okay.
I had a case with the same types of issues, obstruction, the duty to identify, all those issues were in that case with Judge Boulware. Judge Boulware issues an order, and the order is one of your exhibits. It's a different case. And in that order, he specifically cites Heibel and says, police, you're not allowed to do this. He cites the Heibel, right? And we were actually looking for an injunction at that time. However, my client died of colon cancer a month before trial. Because of that, injunctions attached to a person, and our injunctive relief went out the toilet, right? It's gone. We can't use it, right? So they were able to evade it then. But, I mean, cases take a long time, Your Honor. These cases take a long time to go through the federal courts, and that's evading the review, right? Beyond that, additionally, the chilling is still there. This court, I believe, has a responsibility to make sure that people's rights are not chilled. So that's another reason. But beyond it, to go back to back what I was originally saying, this is very likely to happen because Metro is refusing to change their policies and procedures. After Judge Boulware said you can't do this anymore, 2 months later, Mr. Patterson's arrested for it. 2 months. That's after we have a summary judgment decision. They will not change how they're doing things. Even though Heibel specifically said that NRS 171123 is satisfied when a suspect communicates only their name. The word only is there. They say, nope, yeah, we're going to look at this differently. Even though it says only their name. That is their policy currently. Ironically, it's not their training in post. Training in post teaches the other things. I can show you that. But their policy goes against the post training. Their policy goes against the Nevada Supreme Court. It goes against the United States Supreme Court. In my reply, I went extensively through that. I even went through their deposition to where they try to explain, and frankly, it's laughable. They try to explain why they're not changing their policies, even though Heibel says, if you're a suspect, NRS 171123, you must identify yourself, and you satisfy that by giving only your name. Only. They don't care. So of course this is going to come up again. And of course, because the city does not look at every single case and scrutinize the hundreds of cases a day that they get, they're going to start filing complaints. The minute that complaint is filed, vindictive prosecution. Vindictive prosecution comes at the time of the filing because there's supposed to be a check on the government. So of course, this is going to happen again. Will I have the case? Will the person negotiate it so that they can get out of jail? Well, what's going to happen? Do you know how many hours I've spent on this case to try to stand up to this? Specifically because I had another case and Metro's ignoring it. This is important. This is very important for the chilling of constitutional rights. I mean, good Lord. This is important. This will happen again. It is likely to happen again because Metro won't change. And because of the processes and the city or Steve Wilson's processes, they're not going to look through and be like, oh, wait a second, let's scrutinize this. It's not going to happen. So yes, there is an exception to mootness. It's not moot, right? It's not moot because of the chilling. It's not moot because it's tangentially attached to 41.0393. Even if it was moot, and you get past those two, there's the exception, because it's likely to happen again, and it's evaded review. Judge Kearns assured it to evade review when he allowed them to cure, even though the Ninth Circuit says you're not allowed to do that. So judges can just keep doing it. All they have to do is, we're going to cure. The district court's going to say it's moot anyway. We could just Keep letting them cure. They will never have an official stamp that says, vindictive prosecution, stop. That's all we're asking for. We are asking for the court to simply say the words and recognize that in these circumstances, you should not file a complaint. That's all we're asking for with the vindictive prosecution issue. Specifically because the Ninth Circuit says Judge Kearns can't do what he did. You cannot cure the chilling effect by amending the complaint. That's binding case law. That's all we're asking on the vindictive prosecution. And, Your Honor, if you would like to, I would love it if you'd issue injunctive relief that says, Heidel is good law, city. You are not allowed to file a complaint or prosecute based on failure to identify if they state their name, in accordance with Heidel at both the United States Supreme Court and the Nevada Supreme Court. Thank you, Your Honor.
Okay, thank you very much. And at this time, the court's going to make a ruling that the lower court is affirmed as to the first issue. There's no rule, statute, case law that allows the court to take appellate jurisdiction. And as to the attorney's fees issue, the court's going to make a finding that in the statute, courts is specifically defined and municipal court is left out of that definition. So the lower court was correct in indicating they had no jurisdiction to issue attorney's fees or hear that attorney's fees application.
Thank you, Your Honor. I'll
City
prepare the order.
prepare the order?
Yes, Judge, thank you.
All right, and